You love your family, but the law doesn't know that. Without a will, New Jersey decides who inherits your assets, and the people who matter most to you might get left out. Coming up in this video, you'll learn 3 things every New Jersey resident needs to know about what will happen if they die without a will. First, who inherits first, and why that might surprise you. Second, how different family situations affect who gets what, like what happens if you're married, have children from a prior relationship, or have no close family at all. And third, what happens when no clear heirs can be found and why your estate could end up going to the government. Stick around because understanding these rules could help you prevent unnecessary conflict, protect your loved ones, and make sure your wishes are actually carried out. Let me tell you about a woman I worked with a few years ago. Her husband passed away unexpectedly, and he didn't have a will. Naturally, she assumed she'd inherit everything. After all, they'd built a life together, shared a home, and had joint accounts. But here's what she didn't know. Under New Jersey law, when someone dies without a will and has children from a prior relationship, the surviving spouse doesn't automatically get the entire estate. By the time she came to see me, she'd already learned the hard way that a big portion of her husband's assets were going to his children from his first marriage. Kids she loved, but not what either of them had intended. It was heartbreaking, not because anyone did anything wrong, but because they never put their wishes in writing. The law took over and it followed the formula, not the relationship. That's what we're here to talk about today. How New Jersey decides who inherits if there's no will, and how you can take back control before it's too late. Let's start with the basics. Dying without a will is called dying intestate. When that happens, New Jersey's intestacy laws decide who inherits what. And those laws don't care about closeness or common sense. They follow a legal formula based on relationships. Here's what that looks like in the simplest situations. If someone dies and the only survivor is their spouse, no kids, no parents, the spouse inherits everything. If someone dies with children but no spouse, then the children split the estate equally. And if the person dies with a spouse and all their children are from that marriage, the spouse still inherits the entire estate. But things get more complicated and more surprising when the family isn't so simple. Let's say the person who died had children from a prior relationship. In that case, the spouse doesn't inherit everything. They get 25% of the estate, not less than $50,000 nor more than $200,000, plus half of what's left. The rest goes to the children from that earlier relationship. Here's another one. Suppose the couple had children together, but the surviving spouse also had kids from a different relationship. That same rule applies, 25% plus half, and the rest goes to the decedent's children. Now, let's say there are no kids at all, but the person who died still has living parents. In that case, the spouse gets 25% of the estate, again with the $50,000 to $200,000 range, and 75% of the rest. The decedent's parents, what's left. And what about unmarried partners? They're not legally recognized in New Jersey's intestacy laws, so unless you put it in a will, they inherit nothing. Same goes for stepchildren. If they weren't legally adopted, they don't have a claim either. If there's no surviving spouse or children, the estate goes to the parents. If the parents aren't alive, it goes to the siblings. If no siblings, it moves out to more distant relatives, aunts, uncles, cousins, that sort of thing. And if no eligible relatives are found at all, everything goes to the state of New Jersey. In other words, the government keeps it all. Now, not everything has to go through this process. Some assets pass outside of probate. Things like life insurance policies, retirement accounts, and property held jointly with rights of survivorship, including everything owned jointly by spouses. And that all goes straight to the named beneficiaries or co-owners. But, and this is a big one, you have to keep those beneficiary designations updated. Otherwise, even those assets can end up tangled in the wrong hands. So why does this matter? Because when you don't make a plan, the state uses its own. And that plan can create real problems: family arguments, legal costs, long delays, and people inheriting things they were never meant to have. Worst of all, it can cause damage between your loved ones that they might never repair. Remember, intestacy is the state's plan. It's not necessarily your plan. So now you know. If you don't have a will, New Jersey has one for you, but it might leave out the people you care about most, along with causing unnecessary conflict or giving control to someone you never intended. But here's the thing most people don't realize. Even if you don't have a will, that doesn't mean your estate plan is complete. A will is just one piece of the puzzle. If you want to make sure your assets go where they should, avoid probate problems, and keep things smooth for your family, there's more you need to know. That's why you should watch my next video about whether a will is enough and what you're missing without an estate plan. I'll break down what goes into a complete estate plan and how to make sure nothing and no one gets overlooked. Because protecting your legacy shouldn't stop with just writing a will.